Welcome back to the HR Exchange podcast. My name is David Rice. I'm the editor of the HR Exchange Network and your host. And I'm joined today by Don Schroeder. He is a partner at Foley and Lardner in the Boston area. Welcome, Don.
Hey, thanks a lot, David. Thanks for having me.
Yeah, absolutely. So I wanted to get you on. We've seen, I think it was last week, the president signed an executive order regarding non-compete clauses. So I wanted to ask you a few questions about that. You know, this issue of non-competes, I think it's become more prominent in recent years, or maybe I'm just noticing it more. But aside from there's been a California statute that bans non-competes. I know Massachusetts enacted legislation which implemented some kind of specific restrictions on when and how a non-compete restriction could be applied and under what circumstances. But can you give us a bit more background on what this executive order stems from and why it became such a priority for the administration?
I think it goes back to really the campaign that President Biden had. It's the issue of competition and ensuring that there's not unfair competition was one of the pillars of his campaign. And I think this is just his effort to ensure that that they're meeting those obligations, that holding true to that sentiment. I think that's what is in some ways spawning it. I also think you've got Illinois, Oregon, Nevada on the heels of Massachusetts, what I consider to be the mini California of statutes in this area, enacting non-compete laws in varying forms.
Okay. I'm curious, are there certain industries or roles within an organization even, that would be exempt from this?
So there hasn't been any sentiment there yet in terms of which industries would necessarily be exempt. If I had to kind of predict what I think would happen, whether it be the non-exempt kind of major classification or like for instance, the fast food industry, right? There's been this huge effort to get the minimum wage up, specifically in the fast food industry, among other places. And so I could see certain sectors where non-competes would be prohibited. Like you wouldn't be able to and there are other states that have, the janitor rule, right? The janitor can't have a non-compete. And so I think, the likelihood of it being in, say, the fast food industry, the manufacturing industry, prohibiting them for non-exempt workers or a more of an umbrella approach, I could see any one of those scenarios play out, if not all of them in some varying ways.
Okay. So I'm curious, in an executive order, it's not exactly a law. So I'm curious, how closely do you think companies will adhere to this, and what impact will this have on non-compete cases that are being litigated right now?
Well, I don't think it'll have an impact right now on cases because you're either going to be the courts are going to draw their decisions either from existing case law in the state that you're in, so state by state basis, and or statute if there is a statute in place. So I don't really think that it's going to have any immediate implications for the private sector. And it isn't. It's an order, but it's also an order that's kind of it's not setting down an edict. It's ban or limit non-competes. I mean, it's a little wide open there in terms of the breadth of direction that the president is giving, and I think those words were probably chosen very carefully. And then the FTC has to make rules, and then the question will be whether or not they have proper jurisdiction if they do in fact make rules. You've got the youngest FTC chairperson ever, and who certainly did have bipartisan support for her appointment. And she obviously has written about things like unfair competition. So it'll be interesting to see how proactive this FTC will be in the next few months. But even if you assume that they go down this road, there's, a few months of rulemaking, a few months, there's notice given to the public. I'm sure there'll be some backlash to whatever comes out because it'll be more than whatever existed previously coming from the FTC. And, it's not likely to really be enacted, I think, until sometime in 2022 in some form.
Is that just the kind of logistics of figuring out how it looks, or kind of why is that that time frame?
So just in general, they have voted, the FTC has voted to streamline more of the procedures for rulemaking. But even if you incorporate those in and you think about, where we are, middle of July, the likelihood of rules being fashioned on this specific topic of non-competes and then going through the notice and those processes, and the one thing that the FTC commissioner chair person has been very clear about is transparency. So I think there's going to be efforts to make sure that people are aware of what they're doing. So I think when you factor all those things in, I think the likelihood of something being rolled out in a formal way with some kind of authority behind it, I'd be shocked if it happened before the end of this year.
Oh, the FTC as the sort of regulator on this, how will they look to enforce this order? What is the likelihood? You mentioned bans versus limiting non-competes. Kind of what's the likelihood of an outright ban, or is it more likely that we just see limits placed on them?
I think it would be unlikely to see an outright ban. I think that there's a tremendous amount of support behind having some form of non-competes, no matter what, and specifically in the tech industry and life sciences industry. So I could see a huge opposition to an outright ban. That said, I think putting some limits on what industries they apply to, what level of employee does it apply to, whether you do that based upon, economic salary tests, kind of like the Fair Labor Standards Act, exempt 100,000 and above, as far as the exempt categories, the exemptions, maybe they would apply something similar in this regard. But I think an outright ban is unlikely at this point to just go from, 0 to 60 in one fell swoop. And to remember that there were like 70 initiatives, I think, under this executive order. So this wasn't like a situation where ban or limit non-competes, that's my executive order. It was, in the context of like 69 other initiatives as well.
Seems to be the one that really grabbed people's attention, maybe.
I think so. Well, it certainly, has a little bit more, from a media standpoint, a lot more traction than maybe some of the other parts of the executive order.
I'm curious, what are some of the legal challenges that might arise, once this order is implemented from both employers or employees? What might that look like?
So, obviously you'd go into federal court, either under federal question, and you could argue separation of powers, or is it a regulatory taking? And I think those are harder arguments to make, but I think the jurisdictional statutory challenges is the way it would start. The FTC hasn't ruled on this before, so what's giving them the authority to do it now, I think, will be the cornerstone of any opposition. There's no private cause of action to enforce the FTC Act right now. So, how would this really play out, even if you have this FTC regulatory guidance? Would it be a kind of guide for state and federal courts to look at and to latch onto for purposes of perhaps limiting the scope of a non-compete in a particular case? But, they do have to take into account the fact that every state has a different view of non-competes. And, you go from absolute bar in California to Massachusetts having, a 1-year non-compete, but you got to have a 6-month garden leave. It's certain categories of people are exempt. to, other states that have a varying form of non-compete, non-solicit restriction. And so, I think that has to be taken into account, because the landscape is all over the place. I mean, I've litigated non-compete cases up and down the East Coast, and state and federal court, and they're all different. They're all different. You just have the basic themes and the basic, paradigm or structure for what the arguments are for enforcement of a non-compete or opposing an enforcement of a non-compete. But in terms of the law and how it's applied, it's a free-for-all based upon all the states right now.
Interesting. So how much do employers, would you say, need to kind of alter their contracts for the future, or kind of re-examine the ones that they have for current employees?
I think this is, I wouldn't say this is at the top of the list of priorities for an employer right now. I think we've got to, return to work from the pandemic,
Yeah.
Dealing with the COBRA subsidy. There's probably like 5 or 6 what I would consider to be hot button employment items, or topics, or subjects that employers have to deal with. That said, it's certainly in the top 10. I would say maybe 9 or 10 down on the list. And I would say, if you haven't looked at your non-compete or restrictive covenant agreements, your RCA agreements, in, say, a couple of years, I think now is a good time to think about it. Obviously, you'd want to think about the fact that it's likely that there will be some form of restriction as some regulatory guidance on what should happen going forward. And I think it's like one of the major topics that, it's in the top 10. It's not the highest priority right now, but do I think by the end of 2021, going into 2022, that it'll rise higher up on the list of priorities for employers? I think that's true. And so, starting to think from a big picture 30,000 foot level and going down, I think is appropriate now, to kind of look at, all right, what departments and what levels of the company need a non-compete? Is our non-compete narrowly tailored to our specific business or industry? And how long is it? And for what's the scope of it? It's not unusual to have what I consider to be a national scope at this point, given the way the economy works and how industry is today versus, say, 30 years ago. But duration's a huge issue. And, do you have a 2-year non-compete right now? Well, is that really appropriate? Should it be 18 months? Should it be 12 months? How far back do you look in somebody's career? 12 months or 2 years back, so that you try to have a non-compete that you don't necessarily know which way one particular judge is going to rule, and because that's what makes this area fun in some ways, and challenging. But you want to make it as enforceable as possible. And so, if you haven't looked at your non-compete or restrictive covenant agreements in a while, I think it's a good time to do it. And certainly, if you're a startup company, now is the time to kind of figure that out, so that people understand when they come on board what you're really trying to protect. What is the confidential proprietary information that you want to protect?
We speaking there of proprietary information, when it comes to companies that have a great deal of that. I know you mentioned tech companies. I can also think of companies, in engineering or higher education, even,
Absolutely.
should they be re-examining their legal strategies, and kind of what sort of changes do they need to make, if so?
So you raise a good point. I mean, I think the first thing you have to figure out is, okay, what is our proprietary confidential information that we're really worried about? What is the secret sauce? Is it a particular formula? Is it a particular way of doing business? And have we undertaken the appropriate internal steps from an IT infrastructure standpoint to protect that information? And who has access to it? Do we restrict access to it along those lines? And I think it goes into then, what do you want your non-compete, non-solicit to say? What is the true purpose of this? If it's to keep people out of this industry altogether, just because, Well, that's not gonna win in court. You've really got to show a legitimate business interest in why you're doing what you're doing, as opposed to a draconian, borderline nefarious intent to keep people out of your sandbox, so to speak.
All right. Well, this was good. This is good background on this topic. I know this is only just getting started, so maybe we'll have to have you back down the line if things get heated around non-competes.
Would love to do that. It's a fascinating area. I could tell you that each judge looks at things a little bit differently, even in the same court system, whether you're in state or federal court. And so it's a challenging area, but one that I find it really interesting because it's always evolving, it's always changing, and I think because of that, employers really need to take stock in, like, what are they really trying to do here, and not just throw forms out to their employees and have them sign something without actually having some thought behind it.
Absolutely. Couldn't agree more. Well, Don, thank you for joining us today.
Hey, thanks again, David. It was a pleasure.
Excellent.